Virtual Lesson 5.4, Military Conflict and Dispute Resolution. The peaceful resolution of disputes. Historically, the primary purpose of international law has been to facilitate the peaceful resolution of disputes between states. The basic framework is now contained in the Charter of the United Nations. Article 2, Part 3 states that all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. Article 33, Part 1 states that if peace and security is endangered, the parties shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their choice. This list illustrates a progression from diplomatic resolutions to those where the intervention of a third party is required. Article 33, Part 2 states that the Security Council shall, when it deems necessary, call upon the parties to settle their dispute by such means. Article 34 states, the Security Council may investigate any dispute or any situation which might lead to international friction or give rise to a dispute. Article 36, Part 1 states that the Security Council may recommend appropriate procedures or methods of adjustment. Article 36, Part 3 states legal disputes should, as a general rule, be referred by the parties to the International Court of Justice. Article 37, Part 1 states, should the parties to a dispute of the nature referred to in Article 33 fail to settle it by the means indicated in that article, they shall refer it to the Security Council. Article 37, Part 2 states, the Security Council shall decide whether to take action under Article 36 or to recommend such terms of settlement as it may consider appropriate. Article 38 states, the Security Council may, if all the parties to any dispute so request, make recommendations to the parties. This provision allows for voluntary referrals to the Security Council. An international framework for conflict resolution. The Permanent Court of Arbitration. During the 1800s, it became customary to create temporary arbitration tribunals to deal with international disputes. The Hague Convention for the Pacific Settlement of International Disputes, which was enacted and revised at the Hague Peace Conferences of 1899 and 1907, codified this practice with a set of rules and the creation of the Permanent Court of Arbitration, also located at The Hague, Netherlands. To date, at least 109 nations have signed the conventions. The International Court of Justice. The ICJ, also based in The Hague, Netherlands, was established in 1945 as the primary judicial organ of the United Nations. Its main functions are to settle legal disputes submitted voluntarily by states and to provide legal opinions requested by international agencies or the UN General Assembly. The International Criminal Court. There have been many gruesome acts of genocide throughout history. This occurs when killing goes far beyond military strategy to the point where one group wants so badly to ensure their dominance over a competing group that they attempt to wipe them out completely. There have also been many cases of crimes against humanity, which include the killing or inhumane treatment of civilians or prisoners of war. Prior to the end of World War II, most of these acts went unpunished, as there was no international mechanism in place to prosecute the guilty parties. After the Second World War, however, when the details of the atrocities committed against Jewish, Slavic, and other groups by the Nazis and the Japanese came to light, the international community was outraged and created international courts to conduct the Nuremberg trials and the Tokyo trials. Such courts continued to be created on an ad hoc basis for the next half-century. Some acts of genocide and crimes against humanity were prosecuted, such as the policy of ethnic cleansing carried out by Serbian militants after the breakup of the former Yugoslavia, and the Rwandan genocide, during which approximately 1 million ethnic Tutsis were massacred by the ruling Hutus. Both of these situations inspired enough outrage that the UN Security Council set up two special international tribunals to deal with them: the International Criminal Tribunal for Rwanda, or the ICTR, and the International Criminal Tribunal for the former Yugoslavia, or ICTY. Some post-war atrocities, however, were not addressed by the international community, such as the massacres committed by the ruling Khmer Rouge in Cambodia between 1975 and 1979, and by the forces of President Idi Amin in Uganda between 1971 and 1979. This piecemeal approach to such disturbing events was not sitting well with the world community, so in 2003, the International Criminal Court was established by the Rome Statute of the International Criminal Court. This is a permanent court headquartered at The Hague, but with the ability to set up judicial facilities anywhere in the world as needed. The legitimate use of force. Ancient history includes many stories of glorious campaigns wherein war was waged to increase the territory or resources for a particular nation. In modern times, however, international law prohibits the use of war as a tool in international negotiations. This principle was codified as early as 1899 in the Hague Convention for the Pacific Settlement of International Disputes, and is now entrenched in the UN Charter. The only legitimate justification for the use of force is self-defense of a nation's own people or territory. This concept is open for interpretation and has sparked many international debates. For example, the launching of the international military operations in Afghanistan and Iraq was justified as preemptive self-defense with the aim to prevent future terrorist attacks, but how far should this concept be taken? The notion of viewing the world as a global community has led to a much broader interpretation of protecting people and territory. In addition to self-defense, the international community now also accepts the use of force if it has been authorized by the UN Security Council. One example was Security Council Resolution 83 from 1950, which authorized military action after the communist totalitarian North Korea invaded democratic South Korea. The support of South Korea by the West during the armed conflict and since has allowed South Korea to develop into a progressive and prosperous nation. A simplified test of whether the use of force is legal under international law is whether 1. It is in self-defense, or 2. It has been authorized by resolution of the Security Council. The definition of self-defense. Claims of self-defense are often controversial, and the concept has evolved over time as it has been shaped by legal documents, court decisions, and international practices. The UN has attempted to clarify the meaning of self-defense with the Declaration on Principles of International Law Concerning Friendly Relations and Cooperation Among States in accordance with the Charter of the United Nations, 1970, the definition of aggression, General Assembly Resolution 1974, and the Declaration on the Enhancement of the Effectiveness of the Principle of Refraining from the Threat or Use of Force in International Relations, 1987. The International Court of Justice has helped to define self-defense with a number of its decisions. In Nicaragua v. United States of America, 1984 to 1991, Nicaragua accused the U.S. of taking wrongful military actions, and the U.S. claimed that they had been in collective self-defense due to Nicaragua's policy of supporting rebels in neighboring countries. The ICJ rejected the notion of collective self-defense in this case, ruling that Nicaragua's actions did not justify an armed response. International practice, as found in the actions and reactions of states under different circumstances, can also serve as good predictors or guidelines in determining the limits of self-defense. For example, when Israel launched preemptive strikes against Egypt in 1967, just prior to the Six-Day War, the international community accepted them as it was clear that the two states had been on the brink of war and that Egypt posed an imminent threat to Israel. By contrast, when Israel attacked an Iraqi nuclear reactor that was still under construction in 1981, their claim of preemptive self-defense was rejected by the Security Council since the threat from Iraq was not seen as imminent. In 2003, The United States and Britain led an attack meant to disarm Iraq of its weapons of mass destruction. Since the threat was of an Iraq offensive 1 to 5 years in the future, the justification of preemptive self-defense was unacceptable, and the aggressors had to proceed with a coalition of the willing, a label sometimes used when actions are taken without UN approval. One of former Prime Minister Jean Chrétien's more popular decisions when in office was to refuse to send troops to Iraq. Exceptions to the Self-Defense or Security Council Authorization Rule. Some international military interventions have proceeded without justification as either self-defense or having been approved by the Security Council. In some cases, these actions have still been deemed acceptable by the international community, such as the U.S. interventions in Grenada in 1983 and Panama in 1989, and the NATO operations in Kosovo in 1999. Does this mean that there is an exception to the Self-Defense or Security Council Authorization Rule when actions are somehow morally justifiable? Such actions have been defended as being taken on humanitarian grounds, or for the pursuit of democracy, or for a necessary regime change, as was the case with the removal of Saddam Hussein from power in Iraq. As different countries have different political perspectives, it is unlikely that there would be a consensus on any permanent exception to the rule, except possibly for humanitarian grounds. The U.S.-led NATO operations in Kosovo in 1999 were in response to the campaign of ethnic cleansing that was being carried out by the Serbian forces under Slobodan Milosevic against ethnic Albanians. Since the NATO bombing campaign had not received approval from the UN Security Council, it was technically illegal. However, the Independent International Commission on Kosovo, which was convened after the fact to assess the decision-making involved, concluded that, although illegal, the NATO intervention was legitimate due to the humanitarian goals that were achieved. Due to the frustration felt in Canada after the failure of the UN peacekeeping operation to stop the genocide in Rwanda, the Canadian government sponsored the International Commission on Intervention and State Sovereignty, or ICISS. In its 2001 report to the UN, entitled The Responsibility to Protect, it concluded that sovereign states have a responsibility to protect their own citizens from avoidable catastrophe, but when they are unwilling or unable to do so, that responsibility must be borne by the broader community of states. This conception of the responsibility to protect was adopted at the United Nations 2005 World Summit and confirmed in the 2009 UN report entitled Implementing the Responsibility to Protect. The UN acceptance of the Responsibility to Protect doctrine basically implies that exceptions to the Self-Defense or Security Council Authorization Rule will no longer be necessary. Instead, it is expected that the UN Security Council will quickly give approval to military actions proposed for the purposes of preventing or halting mass atrocities when a state is clearly failing to protect its own population. This position serves to strengthen the authority of the Security Council, which had been undermined each time that action was taken without its approval. Restoring the authority of the Security Council may also assuage the concerns of those who have been critical of the unilateralist policies of the United States in recent years. After the collapse of the Soviet Union in 1991, the U.S. became the world's only superpower. Since then, it made a number of decisions that raise questions about its commitment to international relations, such as its refusal to sign the Kyoto Protocol and the Ottawa Treaty, which bans the stockpiling and use of landmines, as well as the military actions undertaken in Afghanistan in 2001 and Iraq in 2003 without the approval of the Security Council. Methods and strategies for conflict prevention and resolution. The international community employs a variety of strategies to prevent armed conflict, including consensus-building measures, permanent defense arrangements such as NATO, initiatives to control or restrict certain types of weapons, commercial and trade measures such as multilateral arms embargoes, and personal criminal liability for war crimes. Weapons of mass destruction. The destructive force of nuclear weapons was made clear by the bombings of Hiroshima and Nagasaki in 1945, meant to compel Japan's surrender to end the Second World War. After the war, international attention was directed toward the two superpowers, the United States and the Soviet Union, and their possession of nuclear weapons. Serious concerns were raised about the hazards of nuclear testing and the threat of nuclear war. The current focus of international arms control is weapons of mass destruction, or WMDs, which have the potential to kill large amounts of civilians and cannot distinguish between military personnel and civilians. These include nuclear, chemical, and biological weapons, as well as the long-range missiles used to deliver them. The search for WMDs was the now infamous purpose put forth by the United States and Britain to justify their invasion of Iraq in 2003. The search, of course, proved fruitless. Arms control initiatives. The first meaningful measure for arms control following World War II was the Treaty on the Non-Proliferation of Nuclear Weapons, or NPT, in 1968. This treaty allowed the countries with nuclear weapons at the time to keep them with the understanding that they were committing to work toward nuclear disarmament. These were the 5 permanent members of the UN Security Council: the US, the Soviet Union, now Russia, the United Kingdom, France, and China. The other 184 states that have signed the NPT have pledged not to develop or otherwise acquire nuclear weapons. There are currently 4 countries not party to the NPT who are believed to possess nuclear weapons: India, Pakistan, North Korea, and Israel. With respect to the actual reduction of nuclear weapons, there have been a number of treaties between the United States and Russia stating specific targets. The current treaty, referred to as New START, for Strategic Arms Reduction Treaty, is an agreement between the United States and the Russian Federation to cut the number of nuclear missile launching facilities in half. It does not, however, require the reduction of inoperative stockpiled nuclear warheads, which number in the thousands in the territories of both parties. Nuclear-free zones. Nuclear-free zones have been created by different means at the national and local level. These zones generally prohibit nuclear weapons as well as any form of nuclear power anywhere in, under, or above the zone. National legislation, such as that passed in Austria and New Zealand, have created fairly stable and enforceable nuclear-free zones. Municipal governments will sometimes declare their jurisdictions as nuclear-free zones, such as Vancouver and Victoria, BC, Red Deer, Alberta, and Regina, Saskatchewan, although enforceability might be an issue if the municipality finds itself at odds with the provincial or federal government. Nuclear weapons-free zones. Nuclear weapons-free zones do not go quite as far. They prohibit nuclear weapons anywhere in, under, or above the zone, but do not prohibit nuclear power facilities. International treaties have created regional nuclear weapons-free zones in Antarctica, Latin America and the Caribbean, the South Pacific, Southeast Asia, Central Asia, and Africa. In addition, Mongolia has declared itself a one-nation nuclear weapons-free zone, and there are also treaties creating nuclear weapons-free zones on the seabed and on the moon. Transfer limitations. Under the 1996 Wassenaar Arrangement, each of the 40 participating states is responsible for ensuring that its national exports do not contribute to arms proliferation. Canada was criticized in the past for transferring nuclear technology to India, which was then used to develop nuclear weapons. In Canada, it is now the responsibility of the Export and Import Controls Bureau to authorize, regulate, and monitor the import and export of restricted goods, which includes those on the Nuclear Non-Proliferation List. Test bans. There has been an international movement aimed at banning all nuclear explosions for either military or civilian purposes. In addition to environmental protection, this would impede nuclear proliferation by making it difficult to design and test new generations of nuclear weapons. The Comprehensive Nuclear Test Ban Treaty was adopted by the UN General Assembly in 1996, but it has not yet come into force. It will only come into force after ratification by all 44 states that possessed nuclear facilities and participated in the negotiation of its terms between 1994 and 1996. As of 2011, 6 of the 9 countries known to possess nuclear weapons have not ratified the treaty, which makes it very unlikely that such a ban will take effect anytime soon. Security guarantees. Another non-proliferation strategy is the provision of guarantees of security designed to make countries feel protected without the need to acquire their own nuclear weapons. Negative security guarantees include promises by states with nuclear weapons to not use or threaten to use them against the other parties to the agreement. Positive security guarantees include promises by states with nuclear weapons to come to the aid of non-nuclear parties if they are under attack or under the threat of attack by nuclear weapons. Physical control of nuclear weapons. Even more threatening than governments with nuclear arsenals is the idea of nuclear weapons getting into the hands of non-governmental groups, such as rebel groups, criminal organizations, or terrorists. The greatest concerns have been over the nuclear weapons and installations that had been under the control of the Soviet Union prior to its disintegration in 1991. Soon after the collapse, Russia and the United States established the Cooperative Threat Reduction Program to secure and dismantle nuclear weapons and installations located in former Soviet Union states. In addition, the 1980 Convention on the Physical Protection of Nuclear Material provides safeguards against the theft of nuclear material. Missile defense systems. With the technology of today, states must consider the threat of attack by intercontinental ballistic missiles, or ICBMs, which could be launched from anywhere in the world. These missiles travel so fast that conventional anti-ballistic missile systems are fairly ineffective against them. There are currently only 2 missile defense systems in the world that can effectively intercept ICBMs. The Russian A-135 anti-ballistic missile system, set up in 1971 to protect Moscow and its surrounding areas, and the American ground-based mid-course defense system located in Alaska and operational since 2006. The Alaska installations are well placed to protect North America against weapons launched from Asian countries like Russia, China, and North Korea, but would be less effective against attacks launched from Middle Eastern countries like Iran. For this reason, the United States has proposed a Central European site with installations in the Czech Republic and Poland. This is still in the process of negotiation, as many countries understandably have concerns about such weapons either placed in or potentially flying above their territories. Advances in missile defense systems should act as a deterrent to countries considering the prospect of developing or even using nuclear weapons. Chemical and biological weapons. Large-scale chemical weapons were used for the first time during the First World War. The Germans were the first to deploy both chlorine and mustard gases, and the Allied forces retaliated with both gases to a more limited extent. After the war, there was an almost universal rejection of these weapons as being a cowardly and cruel form of warfare that did not distinguish between soldier and civilian. This led to the passage of the Geneva Protocol, which came into effect in 1928 and banned the use of chemical and biological weapons during warfare. One limitation of the Geneva Protocol was that it spoke only to the use of these weapons and did not restrict their production, storage, or transfer. After Iraq used chemical weapons both against Iran and its own Kurdish population during the Iran-Iraq War in the 1980s, there was renewed interest in a meaningful international ban. In 1993, the Geneva Protocol was superseded by the Convention on the Prohibition of Development, Production, Stockpiling, and Use of Chemical Weapons and on their Destruction, also known as the Chemical Weapons Convention. The Chemical Weapons Convention actually required the destruction of all chemical weapons and chemical weapon production facilities. It also established a stringent verification system and required each country to create a national authority responsible for monitoring and reporting to the Organization for the Prohibition of Chemical Weapons. Wartime law. The Hague Peace Conferences. In ancient times, the law was expected to give way when hostilities broke out. All was fair, and there were no consequences to be paid when the war was over. As time went on, though, societies became more civilized as the methods of killing became more advanced. This led to a greater push toward imposing rules on the conduct of war to lessen the negative impacts on both military personnel and citizens, which resulted in the adoption of a number of conventions at the peace conferences at The Hague in 1899 and 1907. The rules were continually updated in response to technological advancements and actual wartime events. The Geneva Conventions. When the world met in Geneva in 1949 to update the rules, they adopted the following conventions, otherwise known as the Geneva Conventions. The first Geneva Convention for the amelioration of the condition of the wounded and sick in armed forces in the field. The second Geneva Convention for the amelioration of the condition of wounded, sick, and shipwrecked members of armed forces at sea. The third Geneva Convention relative to the treatment of prisoners of war. And the fourth Geneva Convention relative to the protection of civilian persons in time of war. To date, the Geneva Conventions have been ratified by 194 countries. The aftermath of war. The Geneva Conventions, as well as long-standing customary law, include the responsibilities that arise when victorious forces are occupying new territory and in control of its people. These include the duties to maintain public order and protect the civilian population. In addition, the occupying power must refrain from and prevent violence to life and person, the taking of hostages, outrages upon personal dignity, and the passing of sentences or carrying out of executions without a fair and proper trial. Unfortunately, the existence of the Geneva Conventions cannot guarantee that post-conflict atrocities do not occur. In Africa, for example, there have been incidents of systematic violence committed against the rival population when rebel forces successfully topple a legitimate government. Since the terrorist attacks of September 11, 2001, the United States has also been criticized for its treatment of both domestic prisoners and prisoners of war. Many people believed to be connected with Al-Qaeda or the 9/11 attacks, as well as individuals captured during the wars in Afghanistan and Iraq, have been detained at the American prison facility located at Guantanamo Bay, Cuba, without the rights normally granted to prisoners. Many, for example, have been imprisoned for years without being formally charged. The American response is that these detainees are not typical prisoners or prisoners of war, but are suspected terrorists, and different rules must therefore apply. Peacekeeping. In 1956, 7 years before he was to become Prime Minister of Canada, Lester B. Pearson held the position of Secretary of State for External Affairs. After hostilities ended during the Suez Crisis between the Allied forces of Britain, France, and Israel against Egypt, Pearson proposed that an international peace force be deployed on behalf of the United Nations. The peacekeeping force was deployed and was of great assistance in managing the aftermath of the conflict, earning Pearson the Nobel Peace Prize in 1957. This was the first UN peacekeeping mission that included armed forces. There have been many since, most of which have included Canadian troops. Canada embraces its role in international peacekeeping, and the Pearson Peacekeeping Centre, established in 1994 with its main campus in Nova Scotia, continues to operate with the mandate of supporting Canada's contributions with education, training, and research. Prior to the Suez Crisis, UN peacekeeping missions entailed observation and monitoring, and since then, they have evolved to include more active involvement, including armed interventions such as those in Somalia and Afghanistan. Such active interventions are sometimes considered to be beyond the realm of peacekeeping and referred to as peacemaking or peace building. Anti-terrorism. Just over 2 weeks after the September 11, 2001 terrorist attacks, United Nations Security Council Resolution 1373 was adopted under Chapter 7 of the UN Charter, and as such is binding on all UN member states. It was drafted to place restrictions on the movement, organization, and fundraising activities of terrorist groups. It requires states to share their intelligence and to refrain from providing any form of support to terrorist groups. It also called upon states to adjust their domestic legislation so that their governments could ratify all existing international conventions on terrorism. For its part, Canada passed the Anti-Terrorism Act in 2001. Security Council Resolution 1373 also established the Security Council's Counterterrorism Committee to monitor state compliance with its provisions.